parties are. This is State versus Timothy Walton. Both sides ready to proceed?
Yes, sir.
Okay. Go ahead and approach. And the appellant may have, well, each side will have 15 minutes, but you may have up to 5 minutes to rebut any arguments, so to speak.
Thank you, Your Honor.
I said, I apologize in advance because I feel like I'm in a fog. My allergies are, we were just saying that commercial for Claire's, and I feel like I'm in that fog right now, so I apologize.
I can definitely relate to that.
Okay, you may proceed.
Thank you, Your Honor. May it please the court, my name is Patrick Akis, and I represent Mr. Walton Kirkendoll. Would the court like a short recitation of the facts in this case?
We always tell the attorneys whatever you feel more comfortable with and whatever you want to do. It's your 15 minutes.
Yeah, thank you. In that case, on October 12th of 2012, Ms. Latoya Tillman left her 3 children with her long-term boyfriend, that would be Mr. Walton Kirkendoll, at their apartment in the Chadwick apartment building. That evening, Ms. Tillman placed the children in their bedrooms, put them to sleep, including her youngest son, Demarius. Demarius was sleeping on the couch when she left with her brother to go retrieve a car from the state trooper's impound lot. That trip took approximately 20 minutes round trip. On the way home, Ms. Tillman spoke to Mr. Walton Kirkendoll, who informed her that Demarius had was breathing very shallowly and appeared to be ill, and that he couldn't wake him up, but that there was no sign of any injuries or anything like that. The unfortunate part is that Mr. Kirkendoll had stepped across the hall to the other apartment across the hall where some of the neighbors had been gathering and having drinks. Mr. Kirkendoll was only gone for several minutes, and the apartment was only a short distance away. Medical personnel was called, Demarius was taken to the hospital, and unfortunately he was pronounced dead.
What is in the record about the length of time that your client was outside of the apartment?
Mr. Walton Kirkendoll stated that he was only across the hall for approximately 15 to 20 minutes. It was a relatively short period of time, and there was also testimony that there was a security system not allowing anybody who didn't reside in the building to enter without permission, and a loud buzzer every time the door opened, and somebody was allowed in. I believe it was actually described as being annoyingly loud. So you could hear it from the second floor where these apartments resided. And Mr. Walton Kirkendoll would have been aware of anybody coming in and out of the apartment building.
Was there testimony that he left the door to the apartment locked or unlocked while he was away?
I do not recall whether there was any testimony of that nature. I do not recall, Your Honor. The 3 issues that we've presented for review in this case are manifest weight, sufficiency of the evidence, and the issue of a Batson claim as it relates to jury selection. As it relates to manifest weight, I don't believe that the state has presented any evidence that would show that Mr. Kirkendoll acted recklessly and that he created a substantial risk by violating his duty of care. Trial counsel made a significant argument in this case that this is no different than if a parent is in a larger home and they are on one side of the home while their children sleep in a bedroom on the other side of the home. These apartments are fairly close together, and that wouldn't be considered a substantial risk. They're in the same building, same residence. This seems to be more of a cultural argument than a legal argument, actually. Mr. Walton Kirkendoll was a very short distance away. He could hear if people were entering or leaving the residence, and he was only gone for a short period of time. I don't believe that shows that he acted recklessly in any way, shape, or form. Nor did he create a substantial risk. I cited several cases in my briefs that I don't wish to waste the court's time reciting exactly what's in the brief.
What's in the record? What are we going to find in the record regarding any access that the child or the other children had to alcohol based on the coroner's findings regarding alcohol?
Your Honor, there was alcohol found in Demarius' system. There were several different numbers. One was very low, one was over the legal limit. Obviously, when a small child, those numbers can be very skewed. However, there was alcohol found in his system. Mr. Walton Kirkendoll stated that he had had a drink earlier, but that he didn't believe it was any place where Demarius could get to it. And Demarius was asleep when he left the residence in any way. There was testimony that there was alcohol found in Demarius' system, but I don't believe that that was a result of any conduct by Mr. Kirkendoll.
Did the state, what did the state, what was the state's theory of count one as against Mr. Walton Kirkendoll? What did they say to the jury?
I apologize. Count one is,
As to the,
I don't have the indictment from me, I apologize.
I think it's the more serious count.
If I'm not mistaken, their theory was that the injuries sustained by Demarius were caused by Mr. Walton Kirkendoll or by somebody while Demarius was under Mr. Kirkendoll's duty of care. Those allegations were not founded, those were proven. Only the child endangering was found to be an issue in this case.
Well, I guess my question is, and perhaps I can ask this state, whether or not the state painted a picture that Mr. Walton Kirkendoll gave the child alcohol.
There was some discussion throughout the case that perhaps somebody had given Demarius alcohol in order to cause him to fall asleep. However, if that is the case, Ms. Tillman testified that Demarius was asleep before she left. If alcohol was provided to the child in order for him to fall asleep, that would not be caused or any conduct by Mr. Walton Kirkendoll. That would actually be by some other person, perhaps Ms. Tillman, but not Mr. Walton Kirkendoll. Your Honors, I believe the more important issue in this case would be the issue of jury selection. There was one African American juror placed in the pool. She was juror number 19. The state used one of their peremptory strikes to remove juror number 19 from the jury pool after not saying a single word to her. Actually, neither side's counsel said a single word to juror number 19 outside of the court's general colloquy. And it's our belief that that would be a constitutional violation as described in Batson versus Kentucky. There's a three-step process for evaluating any potential racial claims when it comes to jury selection. First, the opponents of the claim would have to make a case of racial discrimination. It's my belief that Attorney Stepanek did so. He brought up a claim right away, objected to the dismissal of juror number 19, stating that she was the only African American juror on the pool, and that there is no information for either side to use in order to excuse her for any reason other than her skin color. The state then has to provide a racially neutral reason for the strike. In this case, the state's only reason was that they hadn't spoken to her. They said they only wanted jurors that they had spoken to, but they were not able to provide any other reason. I don't believe that that creates a racially neutral tone. That simply says we're looking at a juror, we don't know anything about her other than her skin color. I believe they've in fact backed up the argument that this was a racially motivated strike from the jury.
I thought I read in one of the briefs that the state said that she was unattentive during the voir dire. Did I misread that?
I believe that was stated by the state, Your Honor. In reading the case law on this, there were several cases where nervousness was cited and even connections to local police departments, but courts were not satisfied with those explanations. Nervousness, unattentiveness weren't necessarily accepted as reasons that would create a racially neutral reason for a strike. So in this case, even if unattentiveness was cited as a reason, I don't believe that would be enough to overcome the Batson claim in this case. Again, neither side spoke to her. If either side had spoken to that juror, maybe they would have found out that she was actually attentive or very attentive or not attentive, but there's no information to back that up. Neither side spoke to her. All they could do was observe the color of her skin.
Was there, I guess I'm presuming from years of sitting on the trial court, that there is a questionnaire that the potential jurors fill out, and the counsel wondered whether there's any distinction between what the information that council may glean from, for example, questionnaire, and can glean from engaging in questions and answers. In other words, if there was something that a juror said in the questionnaire that council might be able to rely on in making a peremptory challenge.
Your
But
Honor,
you're focused just on the fact that nobody spoke to her outside of the
yes, Your
court.
Honor. It's my recollection that nothing was actually mentioned about the questionnaires. If there was any information on juror number 19's questionnaire that would be cause for excusal from the jury pool, I don't believe that was placed on the record by either party.
There would be a need to place it on the record if it's challenge for cause, but if it's a peremptory challenge, subject to a Batson challenge.
I don't know if there's a requirement that they place that on there, on the record. However, I guess if I were in that position, the trial counsel, where if there were any issues that would cause me to try to come up with another reason for excusing a juror that would based on the questionnaire, I would want to be sure to put that on the record. However, that wasn't done so in this case. Also, in my limited experience with jury selection, if there's an issue that I have based on a questionnaire, I would like to speak to that juror regarding those issues. In this case, again, neither party even spoke to that juror, so I don't believe that we can assume there would be any information on the questionnaire that would lead to another reason for dismissal.
And then finally, it seems like there was some discussion about both counsel, both the prosecutor and the defense counsel, focusing in on the first, however, I don't recall what the number of jurors was, and not spending much time questioning those that were later in the numerically in the jury pool. Are we going to find anything in the record as to where the African American juror was within the context of that?
Yes, Your Honor. The African American juror in this case was juror number 19.
19 of what?
I don't know what the entire pool was. I know that Judge Arredondo seats 14 in the jury box, and then usually immediately behind either defense or prosecution's table is a row of another set of individuals. 19 would have been in the number of jurors that I would assume would be moved forward had anybody been stricken for cause or from earlier peremptories. If each side has 5 peremptories, I would assume up to juror number 24 would be a very relevant person to speak to, and this juror was number 19, and again, was not spoken to once. Outside of, as I said, the general colloquy by the court to determine whether there was any initial reason to remove her for cause.
Counsel, you've been into your rebuttal time for a while, but we were asking questions, so do you want to save that, or do you want to keep arguing?
I'll reserve that for rebuttal, Your Honor. Thank you.
May it please the court, my name is Natasha Guerrero, and I represent the appellee of the state of Ohio in this matter. Just with regard to the first assignment of error, sufficiency, and manifest weight, just wanted to go into, I think, a little bit on some of the facts that would have created a substantial risk of harm to these minor children. Mr. Walton Kirkendoll was, in fact, the sole care provider of the children during the time in question here. Prior to actually Ms. Tillman leaving, her brother came to pick her up in order for her to retrieve her vehicle. And Mr. Bullocks actually testified that he observed Demarius prior to leaving, and he was fine. There was actually testimony of earlier in the day. Demarius was showing no signs of distress. He was acting normally in the day before as well. And it was only during this time period after Mr. Walton Kirkendoll was solely with the children that he sustained these injuries. And actually from the testimony of Officer Van Warmer, who conducted several interviews with Mr. Walton Kirkendoll. Mr. Walton Kirkendoll indicated that right after Ms. Tillman left her, as she was leaving, he was, right after she left, he also left the apartment. At that time, Demarius was actually on the couch, and he indicated that Demarius was up at that point, that he was not sleeping, and that prior to him leaving, he actually poured 2 separate glasses of alcohol, one that he mixed with juice. It's a little unclear if he left both there, but he definitely left at least one, the one with the juice and the alcohol mix, that he indicated he left in the same room as Demarius, but prior to leaving. Mr. Walton Kirkendoll also indicated that he actually left the door unlocked to the apartment prior to leaving. He closed the door but did not lock it. He provided information that there were a lot of individuals outside of this party, and the party was in fact across the hall. But he also indicated that he went into that other apartment, and the other apartment door was closed along with the children's apartment door being closed. So there was no direct line of sight, no direct line of being able to hear what was going on in this other apartment where he left the 5-year-old, the 2.5-year-old, and the 7-month-old alone. And there is actually a case out of the 12th district which stated that leaving young children alone does in fact create a substantial risk of harm, and that leaving young children unattended, there are inherent dangers that are common knowledge, which is definitely the circumstances that we have here. You're leaving 3 young children who aren't able to fend for themselves alone in a situation where there's an open container of alcohol that they would have access to in an unlocked apartment where a party is going on across the hall. Also, there was testimony from the coroner with regard to Demarius' injuries. He stated that he had some pretty major injuries to his trunk area that would have caused a significant amount of abdominal bleeding, which would result in him being woozy, faint, acting strange, and obviously the level of alcohol that was contained within his system, the lowest amount being 0.17, which is well beyond the legal limit for an adult, all the way up to 0.457, I believe. And that would obviously have caused some actions or repercussions as a result, also being unbalanced. And these were all symptoms that the doctor indicated would have been readily apparent to any adult. And as previously stated, none of these were present prior to Mr. Walton Kirkendoll being left alone with the children. And obviously he was solely responsible for the children at that point in time. Therefore, the state would submit that there was sufficient evidence, and the manifest weight of the evidence did in fact support the jury's finding that Mr. Walton Kirkendoll was in fact guilty of the charges of child endangering through the second, third, and fourth charges in the indictment. In turning to the second assignment of error in the Batson challenge, Mr. Walton Kirkendoll's attorney actually raised the issue of juror number 19 being the sole African-American juror prior to the state ever actually excusing her as a juror in this matter. So there was a discussion prior to that, and his argument that her being the sole African-American juror, she should be a part of the jury pool, or not the pool, but the actual jury in this matter. The state then did provide the trial court with the reasoning behind its excusal of juror number 19. The first of which being that neither party did in fact engage in any sort of conversation with juror number 19, that they were focusing on those in the box, and actually I believe there was some indication that she was in a second set of jurors that were actually behind the defendant. There was also an indication by the state of her inattentiveness during the questioning during voir dire, and there was a case out of this district, State versus Chapman, which indicated that is in fact a race-neutral explanation for a peremptory challenge of a juror. And the state went even further to indicate that juror number 19 seemed frustrated and upset that she was actually there during that time period, that she seemed hostile, and actually at one point she crossed her arms and stated, "Why do I have to be here?" Which was actually something similar that juror number 14 did, and was the reasoning behind the state excusing that juror from the jury to actually be sat. So the state would submit there was several race-neutral reasons why the state excused juror number 19. And lastly, the trial court made that determination that in fact those were race-neutral reasonings for allowing the state to exercise that peremptory challenge, and that decision should be granted deference because it is a credibility determination with that regard. Therefore, the state would request that this honorable court overrule both assignments of error in this matter, and would request that Mr. Walton Kirkendoll's conviction be upheld. If there are no questions.
I think not, thank you.
Thank you, Your Honors.
You may proceed.
Your Honor's actually waive any rebuttal.
Okay,
Thank you.
that's fine. Well then, thank you both for your presentations to the court. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as we release electronically on our website, the Supreme Court's website. So, thank you. Thank you both.
Thank you.